Record should reflect that a bench conference regarding changes in certain conditions to the bond without going into the exact detail. The court is going to deny the request to change any of the bond conditions.
Thank
The
you.
bond will remain the same.
See you next month.
All right, thank you.
Thank you.
Court does call the case of People versus Kaida Matson.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Michael Vincent on behalf of Kyla Matson. Kaida.
Guys are close, huh? Okay, no, go ahead. Your name, ma'am?
It's Kaida. It's spelled Kyda.
10 minutes ago, she told me how to pronounce it.
Okay, all right.
Long-term memory issues.
So you need an adjournment regarding the additional discovery.
Yes, sir. Quite a bit.
4th or the 11th? I know, I'm looking. She's occupied with Mr. Bellinger, if he'd be quiet. Are you guys done?
I apologize, Your Honor.
No, I know it's your fault. Will the 4th or the 11th be better?
The fourth works, Your Honor.
4th. Probable cause conference in this case will be here on September 4th, 2025, 9 a.m. Bond will continue.
May I address bond?
You may.
Ms. Matson's been clean now for 20 days. I talked with her back there. She has priority health. She can pay for inpatient. She's bonded out in Lenawee County. They are testing her 2 days a week. Her father lives in Lenawee County with her 18-year-old son. She could be released to live with her father. She will follow whatever the court lays out for her to do. She wants a chance to make up for the fact that she missed appointments, missed dropping. Committed to doing this. I've warned her that if by any chance she gets out on bond out of this court, and if she steps even near the line, she'll be back in and it won't be any chance for her to get out. She has 4 children. The youngest is 18. She works as a painter and a landscaper. One would hope with strict conditions she could get out.
Judge wastes no time. Bond change denied. In this courtroom, excuses won't fly. Imagine asking for leniency and being shut down before even finishing your thought.
Response from the people.
Your Honor. She absconded while on a scram tether in the beginning of July. Bond was denied when she was free. I leave it up to Your Honor.
I believe that might have been her husband. My client informs me. And she's not been on a scram tether.
The note I have is that her case prior to this case, she had absconded on a scram tether.
Yeah. And that I was aware of, but also on this case, particular case, she didn't do her drug testing and then didn't appear at court. So I mean, I don't know what assurance I would have that she would come back to the court. She did that. How did you end up back in custody?
I got picked up for drug charges
In Lenawee
Why?
County.
in Lenawee County.
She has an open case in Lenawee County.
So you got picked up there. You didn't turn yourself in, even though you had
I
missed
didn't.
testing and the court date.
I was on my way to turn myself in.
Oh,
I'd hired an
you're
attorney.
taking the scenic route?
No, I wasn't taking the scenic
No,
route.
no, she hired me, so it's definitely not the scenic route. She'd like another chance.
I don't have a problem releasing her to inpatient treatment, but I'm not just releasing her. So I would sign an order that the parties can stipulate to for release to inpatient treatment. But just to release her back out, I'm not doing that. She's not done anything, was not going to turn. She still would not be here if that warrant hadn't been out. She didn't come a volunteer.
Hired you.
Not to argue with the court, of course, but she was intending, she hired us and she was intending to turn herself in, but Lenawee County got in the way. That is what I've been told. And I do know that she did hire us.
I didn't know that I had the warrant for Lenawee County, Your Honor. I was picked up on it they came to my house. I didn't fight them. I complied with everything. I just would like to be given the chance to show that I'm
The
clean.
inpatient treatment, I'll release her in a PR. So council can
Yeah, I'll go
action in order
inpatient.
to that respect, but I'm not just releasing her out. She has a
Got it. I know.
court's trust to do that. Motion for bond reduction or change in conditions is denied.
Talk to you in the back. Thank you.
You're welcome. Court does call the case of People versus Gregory Sistra.
National people.
Which case is this?
Can't.
Oh.
Even names become dramatic. Mispronouncing Qaeda sparks correction. Courtrooms are strict, even about identity. Get a name wrong here, and it could feel like another charge added.
Stephanie Cannon on behalf of Mr. Trunk.
We all knew that long before you showed up. Go ahead.
Yes, Your Honor. I am asking for an adjournment. I have a green sheet. As the court can see, he is in hospital. When I tried to go see him, I was informed that he was. So I have not had the opportunity to discuss this case with him. So I'm asking for a 2-week adjournment, Your Honor.
Oh, okay. You want the 28th then?
That is perfectly fine.
I have that date correct.
That's correct.
Probable cause conference, September 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Mr. Sistra.
Thank you.
August 28th. I meant August 28th. Did I say something? Honest, well. Court calls the case, People versus Richard Halstead.
Andrew Childers, on behalf of the people.
Good morning, Your Honor. Brandon Bird on behalf of Richard Halstead.
I'm just hiding over there or what?
On this official morning, Your Honor. Yes, Your Honor. Mr. Halstead, can you please state your full name for the record?
Richard Lee Halstead Jr.
Thank you. You're requesting an adjournment in this case?
Please, Your Honor.
Without objection, September 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Calls case of the People versus Kevin Davis. Yes, sir.
May it please the court, George Lyons on behalf of Mr. Davis on both files, Your Honor.
And good morning, Your Honor. Amy Reiser.
And seeing you, Mr. Lyons, it does please the court. How are you, sir?
Your Honor, it is always a singular pleasure and honor.
Okay, what are we doing?
If I may, Your Honor,
Yes, sir.
I have two issues. One is that we were just retained. We're still receiving and reviewing discovery. We're going to ask to adjourn this matter. We're also going to ask the court to consider a bond reduction.
All right.
We are opposed adamantly to a bond reduction.
Okay, I'll hear argument in a second, but how much time are we looking at in terms of?
Your Honor, I'm tied down on the 4th. I'm asking for the 9/11 date.
All right.
I've been listening from the back, Judge.
Probable cause will be adjourned September 11, 2025, 9 a.m.
Thank you.
As to bond, go ahead.
Respectfully, Your Honor, these matters arise out of allegations of inappropriate contact with students whom he was the track coach. back in 2016, 2017. My client moved with his wife and family to Florida in 2019. People are alleging that because he lives out of state, he might be a flight risk. Let's look at the facts. But reviewing what I have so far, not only did they know, the police called and talked to him in Florida. He gave them his home address. He gave them his work address where they came and arrested him. His family lives in in Albion, where they have for the last 50 years, where he was raised. And we asked that he be allowed to bond out to the Adrian address in Calhoun County. He has no previous juvenile nor felony record whatsoever, Your Honor.
Response.
And Your Honor, this case involves multiple victims that the defendant had contact with and sexual relationships that he developed through his employment at the school. So he exploited these victims. He ended up having a child with one of them. He had to be extradited from the state of Florida. We requested a $100,000 cash or surety bond. The magistrate set it at $50,000 cash or surety on each file in order not to leave the state. We do believe that he is a flight risk, so I don't see any reason to release him on a personal bond at this time.
Your Honor, may I correct one thing that she said, or rather
I
explain?
hope it's about the child.
Yes, it
Go
is.
ahead. Okay, go ahead.
The child was born when the mother, at age 21, followed him to Florida and had their first child. They had their second child last year when she was 23 years old. So this isn't a part of the underlying body of the allegations, Your Honor. It sounds bad when they put it to you like that. But this child wasn't born out of any activity or contact or allegations when the child was a minor, nor when he was her track coach.
The relationship started when he was her track coach.
That's what I'm,
At Lincoln.
that's what I'm asking. I guess I was gonna ask. The relationship started there. The ultimate culmination, which may have resulted in the child,
7 years later.
happened 7 years later.
Yes.
But the relationship was while he was in a position of an educator over this child.
That is the allegation. Yes, Your Honor.
Motion for bond reduction, considering all of that, motion for bond reduction is denied. I think the bond is set appropriately, if not, quite frankly, too low, given the circumstances, at least as the court understands them now. So at this time, his bond will continue.
Thank you, Your Honor.
Thank you.
Defense scrambles for adjournment, citing missing discovery. This is courtroom chess. Delay tactics versus prosecution pressure. What do you think? Buying time or genuine preparation?
Court does call the case of the people versus, is it Syntasia Callaway?
Alex, on behalf of the people, Your Honor.
Sorry to interrupt you, Joe, on behalf of Ms. Callaway. Ms. Callaway, before you state your name, please.
Tasha Calloway.
Judge, I was just appointed on this matter. She and I just met this morning. I'm wondering if we could have the September 4th date at adjournment.
You guys just met this morning?
We did.
Did you like it?
I do.
We did.
You do?
We have a great going to
Yeah.
lunch.
Full cause conference, September 4th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Ms. Keller.
Let's go home and talk real quick.
Court calls case people versus Dalmatian Osman.
Yes, Your Honor. Brandon Bird on behalf of Mr. Osman. Mr. Osman, can you please state your full name for the record?
And good morning, Your Honor. Alex Warren Green. I'm standing in for Mr. Douche in file 1031.
Both of you are requesting an adjournment.
Correct, Your Honor.
That's correct.
28th work.
28th work, Your Honor.
Sure.
Full cause conference, August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case as people versus Shanice Greer.
Tasha Lottie for people.
Ms. Douche is here. Why do you have to step in for you?
Hi, I'm here.
Judge, good morning. I'm Robert J. Colombo. I have Shanice Greer. Shanice, would you state your name for the record?
My name is Shanice Greer.
Thank you.
Judge, Shanice, as you know, is in recovery court. Judge Kunke's recovery court. This is a new possession case. I thought she was going to be here this morning. I've spoken to the prosecutor. I'd like to waive. Shanice, is it okay if we waive your case to circuit court so it can be part of the recovery program?
Defense pivots to bond plea, highlighting her 20 clean days, supportive family, and 4 children. But remember, judges balance sympathy against past failures. Promises aren't enough in law.
Ms. Greer,
Yes,
your attorney's asking whether or not you wish to waive your preliminary examination, move this case to circuit court so it can be part of the cases that you have before the recovery court.
yes, that is fine.
Is that what you want to do?
Yes, sir.
Okay, you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
All right, you understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right.
Your Honor, we will waive, but there is no agreement for treatment court and there's no guarantee, just for the record.
We'll work that out.
Right. I think Mr. Killawall was trying to just
Yes, Judge.
get everything
In
together.
fact,
in one
she's
spot.
due in recovery court at 11:30 this morning.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Killawall.
Acknowledge receipt of the information. We would waive, my client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
October 7th at 1:30.
October 7th, 2025, 1:30 before Judge Cunky.
Thank you. Shanice, I'll see you at 11:30.
Bond
Thank you.
continue. I hope.
It's my birthday.
What did she say?
I have no idea. She said it's your birthday?
Happy, okay, I'll
Is
see
it
you.
your birthday?
Yes,
Well, happy birthday.
thank you.
You want the courtroom to sing to you?
Huh?
That's not gonna happen, but I thought I'd at least ask. Thanks.
Thanks, Judge.
Court calls the case of the people versus Sherry Walker.
And yes, Your Honor, Brandon Bird on behalf of Sherry Walker.
Mr. Bird would say.
Walker, please state your full name for the record.
Sherry Walker.
We're asking for adjournment today, but I'd also like to address bond, Your Honor.
Probable cause conference without objection will be adjourned August 28, 2025, 9 a.m. All right, as to bond.
Well, August 28th, I don't need to address bond because you're in down farms 9-2,
Yeah.
correct? No need to address bond then, Your
Okay,
Honor.
good.
Thank you.
All right, bond continue.
You and your Honor request, great.
Court calls the case, people versus Adam Bowman.
Andrew Childers, agreeing on behalf of people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Adam Bowman. Adam Bowman, could you state your name for the court?
Adam Bowman.
All right.
Your Honor, at this time, there's been no offer extended. We do believe discovery is complete, so we're respectfully requesting a preliminary examination date.
Here comes the reality check. She skipped drug tests and even missed court. In legal terms, that screams unreliability. Question for you. Would you trust her with bond?
People have their witnesses available August 26th. Preliminary examination will be set in person August 26th, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you.
Thank you.
Thought you were going to address
Oh,
bond.
I'm sorry. I'm sorry, Your Honor. He did want me to address bond. I apologize. May I address bond?
Yes.
I'm sorry. So Mr. Bowman is only being held on this case. He does have other cases pending, but he does have a personal bond in those cases. He is extremely concerned because he's in WCCC and his semester finals are supposed to take place, he indicates, next week. And he's very concerned that he has a Pell Grant, and if he's not able to complete his finals and complete his courses, he's concerned about the implications in terms of his further education, as well as his Pell Grant status. He really is highly motivated to continue his educations. He's willing to do a GPS tether. He's willing to stay away from the University of Michigan Hospital, which is where this allegedly took place. He indicates he does have a place to stay, and he would comply with any other conditions the court would impose.
Response?
He would ask that bond remain as currently set. The defendant has an extensive criminal history, including a prison term for accosting a minor for immoral purposes. He's on the sex offender registry. The facts in this case involve him being extremely threatening to staff at the hospital, exposing himself to staff, threatening to rape and kill members of a nurse's family, destroying hospital equipment. So my concern, frankly, is the mental state of the defendant to engage in that sort of behavior. I believe that he represents a danger to the community.
May I respond briefly?
Yes, you may.
So he is on medication now. Since he's been incarcerated, he has been seeing CMH here in the jail, and he indicates he is taking his medication and he is stable. And I asked him, would he follow up with CMH, or what would his plan be for continuing his treatment if he was able to be released? And he indicated he would follow up with CMH, or he'd go to Packard Health. So I think that's the biggest difference. At the time of this allegation, he was going to the hospital for a mental health crisis. And my understanding was he was not medicated or being treated. And that was in part why he was going to the hospital in the first place. And then the allegations took place at the hospital while he was seeking that treatment. So now he is being treated. He is being medicated. So I think I had a great meeting with him yesterday. It was very productive. And I think he indicates he's in a better position and better state mentally.
Well, the examination is to take place in approximately 12 days. I am disinclined to change the bond given the allegations that have been made. So motion for bond
not guilty by reason of standing.
Alrighty then. Motion for bond reduction is denied.
Thank you, Your Honor.
Thank you. Court calls case of People versus Jalen Kendrick.
Allie said on behalf of the people, Your Honor.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Kendrick. Mr. Kendrick, can you please state your name for the court?
Jalen Kendrick.
Fine.